Well, a very good evening. On behalf of the trustees of the Ecclesiastical Royal Society, can I welcome you warmly to this evening's London lecture, the first of this calendar year. It's very good to welcome so many of you from around the country and indeed around the world, and I especially welcome those of you that are not members of the ELS. Please do consider joining the Society. Details of how to do so are on the website. So as Russell said, that at the end of the lecture, we'll have some questions. You're very welcome to put your questions in the chat function during the course of the lecture, although it would be best if you reserve the chat function for that system in terms of putting your questions there. Alternatively, raise your hand at the end of the lecture and ask your question then, and Russell will unmute you. It's a great privilege to welcome Ian Blaney, who will deliver our lecture this evening. Ian is a partner in the law firm Lee Bolton Monier Williams. He is also Registrar of the Diocese of Lincoln and Derby, Deputy Registrar of the Faculty Office of the Archbishop of Canterbury, and of the Diocese of Guildford. Ian works in the fields of churches, charities, and schools, so he's very well placed to deliver this evening's lecture, entitled Pious Causes, the Boundaries Between Charity Law and Ecclesiastical Law. Thank you very much, Ian.
Thank you, Stephen, and it's very nice to see you all, friends, acquaintances, colleagues, former classmates, counterparties who've all braved storm Eunice to be with us tonight. I'm going to speak for about 50 minutes, starting off with the historical background and then moving towards the present day. Hence, I've got a picture of John Alcock on the screen, who was the 15th century Bishop of Ely and 3 times Lord Chancellor, because they were turbulent times. And he was an ecclesiastic who straddled both charity law and ecclesiastical law by virtue of his various offices. And charities increasingly make up the body politic of the Church of England. They include parochial church councils, diocesan boards of finance, and national institutions. By April 24, every chapter of a cathedral will be required to register as a charity. Faithful parishioners put their collection money in gummed envelopes, which call for them to add gift aid to their donation. Individual churches run food banks, drop-in centres, baby and toddler groups, and a whole range of charitable activities. The general public could be forgiven for thinking that the Church of England is a national charity, but it has not always been the case that the mission of the Church of England has been through its charities. And for much of its history, the Church has remained largely independent of charity law. So I pose the question, what are the consequences of the increasing reliance on charities? And where do the boundaries lie between ecclesiastical and canon law? Okay, well, I'll start off by looking at property. Because, as you will all know, the bedrock of any charitable trust is its property. Every charitable trust must consist of a trust over property, whether land, cash, or movable property. And in Saxon times, and surviving the conquest, there was a form of land tenure, which the Normans came to call Frankelmoin. Generally, ecclesiastics held their land under Frankelmoin and its progenitors. Such land was donated to ecclesiastical corporations, which might be sole, such as the parson of a church, or aggregate, such as a monastic foundation. The land was to be held for spiritual purposes and in perpetuity. When the feudal system of landholding was introduced with the Norman conquest, land held in Frankelmoin was exempted from the requirement that the landowner give feudal services to the king. Instead, they which hold land in Frankelmoin are bound of right before God to make orisons, prayers, masses, and other divine services for the souls of their grantor or feful, and for the souls of their heirs which are dead, and for the prosperity and good life and good health of their heirs which are alive. And therefore they shall do no fealty to their Lord, because that this divine service is better for them before God than any doing of fealty. So says Littleton in his work on tenures. Land in Frankelmoin was not held under a trust, and it remains the case that churches and churchyards are held in a manner which is related to this distant Saxon prototype. Characteristically, under the church property measure, for example, parish churches and churchyards will be vested in the incumbent of the benefice. The incumbent of the benefice holds the land as a corporation sole with perpetual succession. A trust is never in practice declared, although the land is explicitly to be held for a spiritual purpose, namely the worship of God or the burial of the dead. A parish church and burial ground are also typically consecrated and thereby set aside for spiritual purposes and made subject to the jurisdiction of the consistory court of the diocese. Although consecrated church buildings and burial grounds are not, as a general rule, held subject to a trust, whether charitable or otherwise, the ecclesiastical bodies holding them are expressly prevented from falling within the definition of charity in the Charities Act by the exclusion that the Charities Act contains in section 10, and you can read it at your leisure on the screen. Now, consecrated churches and churchyards are an example of church ownership of property falling entirely outside of the regulation of charities. Another example is glebe land, land which was until 1978 held by the incumbent for his personal benefit and is now held by diocesan boards of finance to generate income, to sell for capital monies to pay for the stipends of clergy. Glebe land was held for a spiritual purpose, the maintenance of the parson. While the motive of the donor may well have been charitable in the normal sense of a word, such land is not typically held upon charitable trust. It is another example of what I might call the vestigial parts of the Church of England, which predate the development of charity law and which were established at an early time in the Church's history. Another example would be the parsonage house, also vested in the incumbent, and also formerly tithes. Now, ecclesiastical property was not donated into a void. In terms of governance, it was incipient in the Saxon Church that ecclesiastical corporations aggregate, collegiate churches, cathedrals, and monastic houses would have statutes or some other constitution or rule of life which would determine how they would be run. It was a role of the visitor, the ecclesiastical superior to the corporation, since the early days of the church, to investigate the conduct of all inferior institutions and to correct and reform abuses where they were found. Parish clergy, cathedrals, and monastic houses were subject to visitations by diocesan bishops, and diocesan bishops in turn subject to visitation from the metropolitan bishop. By a constitution of Otho, archbishops and bishops were to go about their dioceses at fit seasons, correcting and reforming the churches and consecrating and sowing the word of life in the Lord's field. Thus, when William, Bishop of Lincoln, came to visit Daventry Priory in 1442 and made anxious inquiry touching the state of the priory and its clergy, and found almost no good among you, nay, verily, religion among you is altogether dead, and your temporalities without which this present life cannot be carried on, are on their way to lose their being, and desiring, therefore, the revival of religion among you, and the more fruitful governance of your temporalities, he suspended the prior, who was of old age and incapable, and was rendering no account of the goods of a priory in accordance with the rule of the Benedictines, from all administration of any temporalities, and vested the administration in the sub-prior. Detailed arrangements were made for the better administration of the goods of the priory and the reformation of the conduct of the monks according to the rule of a house. And we have full records of this from the bishop's notary and registrar at the time, all kept in lovely Latin and available in translation in English. Now, visitation remains a legal mechanism to inspect the fabric of church buildings, check the inventories of movable property, ensure that the institution is being governed properly and in accordance with the rules that pertain to it, that the clergy are following a godly and edifying life, and that religion is flourishing in that place. In that context, church wardens were and remain accountable for the movable property of the parish church. They are required to keep the inventories of this property. They are subject to inspection and visitation by the archdeacon and hold property in a quasi-corporate capacity. Now, this role preceded the development of a law of trusts. It may have inspired in some way that law. And the core duties of church wardens in relation to assets are subject to ecclesiastical, not charity law. Over time, however, charity law has become more influential and integral to the way that the institutions of the church operate. For the early church, while charitable activity was an important outworking of Christian mission, particularly in the giving of alms to the poor and the provision of hospitals for the sick, there was little in the way of a law of charity as such. Charitable activity was the outcome of benevolent religion and of Christian men and women following virtuous and pious lives. It belonged to the domain of morality and did not require regulation, except to the extent that the faithful needed to be exhorted to be generous by those in authority. To that extent, the canon law did, in the words of Richard Helmholtz, set out some basic principles of the law of charity. But as Helmholtz has identified, neither Gratian's Decretum nor the decretals of Gregory IX contained any book or title dealing expressly with charitable institutions, or with the law of charity generally. Where charity was dealt with, it was not claimed as part of the jurisdiction of the church. Now, that's not to say that charity law does not owe a debt to the church, and some authors have said that the concept of si pre, for example, is inspired or developed from the canon law. But it was not considered by the canonists originally to be part of their jurisdiction. But where the law first began to intrude in the medieval times was in the field of testaments, where the church had obtained jurisdiction over charitable bequests, that's money and chattels, personal property, not land, provided in a will to go to beneficiaries. And this was happening by the reign of Henry III. This was a jurisdiction that was to some extent overlapping with the Court of Chancery, which had the, or at least would come to have, the strict legal jurisdiction over charities as a whole. Now, where testamentary gifts benefited the church, they might be held on charitable trust or outright. This depended on whether the gift was worded in such a way to bestow it with the nature of a charitable trust. If the gift was to be held outright, the property was held by an ecclesiastical corporation or by the church wardens under the ecclesiastical law. Property belonging to a parish church and held by the church wardens was subject to the jurisdiction of the consistory court, as it is now. If given on charitable trust, on the other hand, then the vicar, church wardens, or others would hold the property as trustees, as now, and the property will be protected under the law of charities. In time, charitable giving generally became the favoured way in which to re-endow the church and to regulate many of its affairs. From the testator or donor's point of view, it had the advantage of enforceability. If a property was given on trust for a particular charitable purpose, it was incumbent on the church to apply the property according to their stipulations. This gave rise to a species of charity which we would now call ecclesiastical charities, namely charities established for ecclesiastical purposes. And perhaps to save some consonants and some vowels, I'll now talk about church purposes rather than ecclesiastical, to spare me some time. In the initial formulation of charitable purposes contained in that great Elizabethan statute, Elizabeth I, the Statute of Charitable Causes, gifts to churches were not actually mentioned, but clearly gifts for a range of church purposes, such as to maintain a preaching minister, could be charitable at that time. And in 1891, in the Pemsor case, Lord Macnaghten confirmed the advancement of religion was one of the four principal heads of charity. It remains one of the stated charitable purposes in the present-day Charities Act. And since Tudor times, a range of charities, both church and non-church, were administered by the church wardens or the vestry meeting. With the birth of local government in the 19th century, functions of the vestry and the church wardens were removed to the new parish councils. However, the vestry retained any such ecclesiastical charities for which they were trustees, and any powers, duties, and liabilities relating to the affairs of the church. The church wardens retained any charities of which they were the trustees, whether ecclesiastical or not, and their responsibilities relating to the affairs of the church. The legislation helpfully contains a non-exhaustive definition of ecclesiastical charity, which is on the screen and is helpful to us to this very day. Such ecclesiastical charities are common. Seldomly are parishes without them, and they might be held by the incumbent or church wardens, the PCC or named individuals, or a mixture of them. They might help repair churches, pay stipends, promote church music or religious education. They sat alongside their non-church charities that the officers of the church are often the trustees of as well, commonly with the parish as the area of benefit. Such non-church charities include almshouses and village schools. Locally based charities, often established by the testaments of the faithful, or through subscription or generous lifetime gift, sat alongside the ecclesiastical corporations that kept the core property of the church, its churches, churchyards, parsonages, and glebe, and helped animate, bring to life the workings of a church in each parish. Such charities were and remain outside of the strict regulation of the church law. These charities were and remain subject to the regulation and control of the High Court. Before 1875, that was Court of Chancery, and the charity commissioners, not the consistory court, nor the diocesan bishop. As such, they sat alongside and were additional to the core church structures, and with a degree of autonomy from the ecclesiastical law. In addition to locally based charities, charities were also founded in the at the diocesan and national level. It was common and remains common for diocesan bishops and archdeacons to administer charitable funds for church purposes. At the national level, particularly in the 19th century and afterward, charities such as the National Society for promoting religious education had a profound way on the way in which the Church of England could change society. Through the auspices of a national society, facilitated by new legislation and supported by generous benefactors, church schools were established in hundreds of villages and towns, normally with trustees, which took a standard format and which appointed the incumbent and church wardens as the charity trustees. The Society for the Promotion of Christian Knowledge, the Church Mission Society, and many others had a significant part to play in re-evangelizing the nation and beyond. However, the official church structures remain largely independent of charity law. The legislation establishing the governors of Queen Anne's Bounty, represented on screen, 1704, and the Ecclesiastical Commissioners for England, established 1836, were both independent of the jurisdiction of the charity commissioners. But what such national church bodies did do, however, was to concentrate church resources in bodies administered by a mixture of clergy and lay people who would work strategically to promote the mission of the church in a manner that was national, not solely diocesan or parochial, in a way that prefigured the national, diocesan and parochial charity structures that now exist. They went beyond the independence of the older ecclesiastical corporations, bishops, cathedral chapters, and parish priests, whose roles were largely governed by church law, and created a superstructure over them of national bodies which bear resemblance to the 7 national institutions of the Church of England that operate today. At the diocesan level, it was not until the 19th century that experimentation in using charitable trusts to pool and administer diocesan funds began. In the second part of the 19th century, with population growth, the development of new towns, and the need to build new churches, new diocesan structures came to be founded, which could hold land and buildings on charitable trust and channel funding to needed projects. At the annual meeting of the Church Congress in 1880, the Honourable William Egerton MP narrated that during the last half century, the growth of population and the consequent necessity for providing more adequate spiritual ministrations for the masses of our large towns have forced upon the Church the duty of increasing its financial resources and perfecting its machinery for collecting funds. Besides these normal wants, a new difficulty has lately arisen. When the rights of the Church of England to its property are challenged and its endowments are claimed by a minority of the nation, it is time for the Church to consider in what way it can best meet the pressing claims of its members for greater support to its growing institutions and invest the funds collected for these objects with the greatest security for the future. Rising stuff. Furthermore, he commented, the Church of England was wanting in comparison with such religious bodies as the Roman Catholics, Wesleyans, and the Free Church of Scotland, trailing these bodies in having no central bodies to administer funds or to steward property. Aside from the funds and property administered by Queen Anne's Bounty and the Ecclesiastical Commissioners and bodies such as the Missionary Society, SPG, SPCK, and the church building societies, the organization has been wholly parochial, but little has been done by the collection of small sums, except through the offertory. He advocated for diocesan finance bodies, which could realize the potential for financing the church, rather than mainly relying upon the liberality of past generations. And he was not alone. Each diocese moved at its own pace in establishing a range of legal entities which could steward and harness diocesan and parochial property. I'll go into the history of this in more detail if I can get a paper published, but there's something of a potted history on screen of some of the attempts in various dioceses to push diocesan finance bodies and to incorporate or to establish unincorporated charitable trusts to do that. The combination, therefore, of demographic and economic change in England the entrepreneurialism and philanthropy of the church membership, and changes in the law which allowed new legal entities to be created, led to the establishment of diocesan charities in the late 19th and early 20th centuries. Added to this was a change in approach from the legislature, which began in the 19th century to repeal the legal provisions which made it difficult for large landowners to give property to the church, and indeed to incentivize such donations. One of the early legislative acts of the Church Assembly, this is of course the church legislative body itself, was to enact the Diocesan Boards of Finance Measure 1925, which we still have, to give these diocesan bodies a uniform structure as charitable companies limited by guarantee, with common constitutional characteristics. At the parish level, the Church Assembly enacted the PCC Powers Measure 1921, which is pretty much what we've got now, as upgraded and amended and restated, which created statutory charities with a corporate status for each parish. Both these measures gave rise to or condoned existing bodies which operated largely outside of the ecclesiastical law, aside from the extent to which their constitution and practice were set out in the legislation itself. They were and evidently are church corporations with trustees appointed from church members and established for church charitable purposes. But the canons of the Church of England, which were largely those of 1604 with some updates, made little or no mention of them. And when the revised canons ecclesiastical were promulged by the congregations of Canterbury and York in 64 and 69, respectively, current canons, as important as DBFs and PCCs are in today's church polity, and indeed bodies like Archbishop's Council, gave little mention to them, little or no mention. The consequences of this will be considered low. Let us compare, or let me compare, the characteristics of charitable property from church property to try and find out where the dividing lines might be. And distinguishing features of charity property, as you charity experts will know, is that the separation of legal from the beneficial interest in the property. That is to say, that the legal owners don't hold the property for their own benefit, but for someone else, the beneficiaries of a trust, being the public at large or a section of the public. The property is held exclusively for a purpose which is considered by the law to be charitable. The property is applied in the public benefit, and private benefit can only be incidental. That is to say, the trustees cannot apply the property solely for their own benefit or for a particular family or club, but for the benefit of a section of the public. There's normally more than one trustee, doesn't have to be, but that's the traditional approach, the trustees to watch over each other. And the charity is subject to the control of the High Court and the Charity Commission concurrently. Subject to charity law, including the Charities Act. This brings with it reporting and accounting requirements. Also subject to trust law, the law of equity and trust. The property holding does not fall foul of a law on perpetuities, the law which prevents property from being tied up for a particular purpose for too long. In theory, charity trustees and their successors could hold the property forever. And the disposal of property is regulated, in particular to prevent trustees from disposing property without a power to do so, or imprudently. Ecclesiastical property, on the other hand, I don't wish to create a dichotomy necessarily, but these are some characteristics. The possibility of holding the property for the benefit of the owner is not precluded. In the case of Glebe before 1978, it was the case that the land could be held for the private benefit of the incumbent. It is still the case for parsonage land. There is no necessity for there to be a trust at all. Church corporations have perpetual succession. That means, an incumbent or a bishop, their successors follow them in their office and form one continuous, largely unbroken, or at least reanimated corporation through history. And thus inferior can hold property forever. There's no problem around perpetuities. Indeed, such corporations preceded the development of the law of perpetuities. Most kinds of church property are subject to restriction on disposal. Property which is consecrated is held for sacred purpose. For example, the burial of the dead. Consecrated property is under the jurisdiction of the consistory court, and alienation is highly regulated. And church corporations are subject to the regulation of the visitor, who can investigate to ensure that property is being cared for, that the corporation is following the rules that it is subject to, and the life of the church concerned is healthy and godly. And the categories of non-charitable, ecclesiastical property predate modern charity law, and the way the church law developed was such as to create durable, stable, prudential and certain property holdings that did not require the assistance of the charity law. The church and its law had its own ways of regulating the holding of property and monitoring and correcting the health of its institutions that existed and still do to a large degree exist. I've got this topic now of conceptual differences, and I don't really want to go into it in any detail, but there is this idea that before the Reformation, property could be given for various pious causes, such as the saying of masses for the dead, which didn't require any public benefit, didn't require any positive impact on humankind to be demonstrated. And then with the Reformation, superstitious uses were stamped out, they were prohibited. And then with the Elizabethan law of charity, there's this requirement, really a sort of what Michael Blaney in an article talks about, sort of Protestant bias, a utilitarian approach that is betrayed by the legislation, and it runs through the legislation to the present day. And the case law, that case about enclosed community of nuns, where it was found that these nuns weren't exhibiting any public benefit because, well, how can we test the efficacy of their prayers and their activity? And it was found, well, there's no public benefit, they're not charitable. There's this bias, you could say, in charity law, that charities must be established for good works for mankind, not as servants of God. So I just raise this because our early ecclesiastical corporations, burial of the dead, worship of God, the benefit to mankind was sort of subsidiary, what flowed on from the original purpose, which was to give something over to God. But if we look at our modern charity structures, our PCCs and our DBFs, they have proper charitable objects to for example, PCC to work in coordination with the incumbent. The whole mission of the church, pastoral, evangelistic, social and ecumenical mission, is at the forefront. So I think there's an interesting difference in those old ecclesiastical corporations and the modern ones, and the fact that they don't always necessarily tally. The old ecclesiastical law didn't require this concept of public benefit, but charity law now really, it is the litmus test of one of the litmus tests for what makes a charity. The whole phrase, the advancement of religion, which is one of the heads of charity, has that in the ring of it. That's all I think I wanted to say on that point. So what have we got now in modern day Church of England? And I apologise for those of you who are outside of this great church, but maybe we can look at parallels in question time. The present state of the Church of England is that its institutions are partly the vestigial parts of the Saxon and Norman church that have survived, namely the church corporations holding onto large parts of the property of the church and governed by church law, and wholly or mainly clerical. and the charitable trusts that have sprung up, particularly in the 19th century and onwards, PCCs, DBS, and national institutions, in which lay people are members with the clergy, which are governed both by church law and by charity law, but with charity law being the dominant form of regulation. Now, whether the mix is a healthy one depends on perspective. Is the mix like a seemingly smooth and comfortable mattress, which when one lies on it, the rusty iron cores beneath come frosting up to jab the unsuspecting sleeper in the back? Or is it a rich and complex ecosystem, which is more resilient and flexible for the fact of having the different components? The first point that is worth making, or I think is worth making, is that the older ecclesiastical corporations serve different functions from the newer. In the parish church, it is a minister who has conduct of all ministerial functions. That minister is in charge of the conduct of services, the administration of the sacraments, the burial of the dead, and so forth. Thus, most ministerial and leadership functions fall outside of the strict parochial church council functions. They're only governed by church law, not charity law. On the other, if you look at PCCs, on the other hand, they're responsible for the financial affairs of the church, including the collection and administration of all monies raised for church purposes, and the keeping of accounts in relation to such affairs and monies, and the care, maintenance, preservation, and insurance of the fabric of the church and the goods and ornaments. The PCC has a right to be consulted on a range of matters, and generally its purpose, as I mentioned, is cooperation with the minister in promoting the mission of the church in its various ways. And in its administration, PCC is governed by its members who are charity trustees. Okay, let's look at the Darson level now, the Darson bishop. It's a bishop who has a discretion whether to give license or permission to officiate to a cleric, who may license buildings for worship and marriages, consecrate churchyards, and generally be the chief pastor of the diocese. Such matters are wholly within the ecclesiastical law, not charity law. Look at the Darson Board of Finance, the counterpart to the bishop or the partner of the bishop. Its role is to hold property and funds. It is empowered to fulfill staffing of the diocese in terms of the central staff, to collect contributions from parishes, and to provide central services. It is administered by trustees and company directors, owing duties in both company and charity law. So different bodies, different functions. And the second point is that the pure church laws and the modern, rather pure church corporations and the modern charity bodies are connected. The incumbent, who is the corporation soul in which the property of a benefice is vested, who has the cure of souls and the superintendence of all the ministerial functions, and is beholden to canon law, is ex officio a member of the PCC and its chair. The Darson bishop, who has the cure of souls of the diocese with their clergy, and who discharges his or her multifarious functions under the church law, is ex officio president of Darson Synod, chair of various Darson boards, and a director and charity trustee on the Board of Finance. This is the sweetness, as I see it, of the present combination of the old and new. Clerical office holders keep going the ministry, the apostolic ministry of their forebears, and are plugged into modern charitable governance bodies which take care of the resourcing of ministry and which provide advice, support, and are a check to what otherwise would be overweening clerical power. Now, where matters get a bit blurred is in remembering where the pure ministerial functions stop and the charity governance functions start. In both PCCs and DBFs, the minister and the bishop respectively are, one could argue, first amongst equals. They chair those bodies, but they are not supposed to dictate to them. Each trustee is themselves responsible for ensuring that the charity as a whole is conducted in such a way that ensures the best possible promotion of the objects of the charity, exercising such care and skill that they have. The third point I have is that the mixed economy of the church corporations and the modern charity bodies is not always well understood by church leaders, nor properly mapped out in the canons of the Church of England. Partly this is because large parts of what makes up the Church of England is contained in measures, church legislation, and has not been recognised in the canons themselves. And in the case of parish share, for example, is neither contained in the canons nor church legislation. Additionally, as newer charity bodies such as PCCs and DBFs have taken over running large parts of the church law has not always been amended to recognise that fact. Take visitations, for example. As mentioned, visitations were one of the key investigative and enforcement mechanisms of the church. But it is doubtful in my mind whether a diocesan bishop, I speak in a personal capacity, has a right of visitation over a PCC. No legislation or canon provides for that, and the establishment of PCCs post-date the customary law of visitation. Therefore, when diocesan bishops hold PCCs to account for the visitorial process, the enforceability of such process, aside from via the incumbent and church wardens, is doubtful. While there are some supervisory powers over PCCs, such as the Archdeacon's right to inspect minutes and to call for an extraordinary meeting, they are independent charities on the whole, run by charity trustees, which owe their duties in their charity law, in the PCC powers measure, and who might be undermining their independence should they abdicate what they think is prudent out of deference to the directions of a superior ecclesiastical power. Well, why does any of this matter? Is it just an exercise in taxonomy, labelling the different flora and fauna in the Church of England ecosystem and discovering their origins? I mean, personally, I find ecclesiastical law and charity law so often conflated, ignored, or confused that it's helpful to start to stick labels on the different parts and see how it all fits together. This is the Ecclesiastical Law Society that I'm speaking to, and it's worth taking stock of how much of what church members work with is pure church law made by the church or outside law, which has flowed in and often been modified in the process. One consequence of a division between ecclesiastical and charity law is jurisdiction. Ecclesiastical law is church-made and church-controlled. Consecrated churchyards, for example, are regulated by the consistory courts and clergy disciplined by church courts. Charity property, however, is under the jurisdiction of the High Court and the charity commissioners. While the bishops of the church are not perhaps as interested as they once were at maintaining the independence of the church from control by the state and by the secular courts, it remains the case that supervision by the High Court is supervision by an outside tribunal. The related consequence is that the church does not write charity law. It exists for all charities, whether ecclesiastical or not, and is influenced by legislative change, case law, and by policy considerations. And high-profile campaigning around independent fee-paying schools and whether these should have charitable status has shown how political the question of public benefit can be. While ultimately a fee-paying school could seek to cease to be a charity and thereby act independently of public benefit advice issued by the Charity Commission, if by statute all PCCs, DBFs, and cathedral chapters have to be charities, that does not give the church much room to manoeuvre if charity law was steered in a direction that compromised the tenets and practices that the church holds to. The church, the approach of the Church Charity Commission has been benevolent. I admit this, and they had to be cajoled into intervening in the dispute between the governing body of Christ Church in the University of Oxford with its former dean. But all 7 national institutions of the Church of England are subject to regulation by the Commission and charity law. And that's just an interesting point to note. While the registration of cathedral chapters as charities, a requirement of the new fangled cathedrals measure 2021 may have the mere ring of going through some formalities in order to have cathedrals on a register and to make them comply with some additional accounting and reporting requirements. The transformation is, in my mind, rather more significant than that. I think it represents the first time that an old style, non-charitable church body is being converted into a new style, charitable one. I might be wrong about that, but cathedral chapters, in my mind, have never been charities, at least since the first Charities Act, well, the Elizabethan statute. They've always been put outside, and in order to get them into a state where they become compatible to be registered, it has been necessary to determine what charitable purposes they act in. The purpose of a cathedral has never before been fixed. And when Norman Doe came to catalogue what each cathedral thought its purpose to be, he did not find that there was a common view. One of the key functions that the cathedral be or contain the seat or cathedra of the diocesan bishop has been made an ecclesiastical purpose of the cathedral, rather neatly, I think. Thus, in section 1 of the measure, it states this, that a person on whom a function is conferred under this measure must, in exercising that function, have due regard to the fact, as the measure seems to have it, that the cathedral is a seat of the bishop and a centre of worship and mission, and the importance of each cathedral's role in providing focus for the life and work of the Church of England in the diocese. That's the ecclesiastical purpose. But cathedrals also have charitable purposes, which are different, and they appear in section 4 and include purposes. The main one is to advance the Christian religion in accordance with the faith and practice of the Church of England, in particular by furthering the mission of the Church of England. That's a positive public benefit, good works, charitable purpose, and to care for and conserve the fabric of the building, a preservational object. Thus, the measure neatly lists the ecclesiastical purpose derived from canon law in the first section and prescribes the charitable purposes of the controlling mind of the cathedral, its chapter in the fourth. This helps to embody the separate church and charity law elements which go into making what a cathedral is, or is now. One of the remarkable aspects of the cathedral's measure, which went largely unnoticed, was that it linked eligibility to act as a charity trustee to the right to hold ecclesiastical office. It inserted a new section 3A into the terms of service measure, which stipulates that if an ecclesiastical office holder, such as a dean or residentiary canon, is by virtue of that office a charity trustee of the chapter, which they will be, but is disqualified from being a charity trustee under the Charities Act, then the diocesan bishop must remove that person from office, from their church office. While the office holder may remain in office pending an appeal under the Charities Act or pending an application to the Charity Commission for a waiver, neither the bishop nor anybody exercising ecclesiastical jurisdiction has any discretion in the matter. The bishop must remove the office holder as soon as reasonably practicable, and in any event, before the end of 30 days, beginning with the day the appeal or application for a waiver is determined, and during that time must suspend the cleric. This is a serious inroad into the protections afforded to clergy on common tenure as to the security of office, and makes the clerical office subject to the disqualification provisions on the charity law. While there is some internal logic here, I can see why it's been done. It makes the clergy far more vulnerable to removal than before, and removes the authority of the church to determine who should be removed from ecclesiastical office. There's no compensation for loss of office. And although most of the disqualification grounds relate to serious matters, they do also include some matters which would not necessarily amount to clerical misconduct, such as those who are undischarged bankrupt under the insolvency legislation. It would also make the Charity Commission the arbiter of who should be given a waiver. Who knows how the disqualification rules may be altered in the future to expand the net wider. It reduces the independence of a church to determine who is fit to hold an ecclesiastical office. Even for those priests and deacons who have been found guilty of a criminal offence, such as murder, to which a custodial sentence is attached, or those clergy which are put onto a barred list. There's a procedure under the CDM for representations to be made to the bishop as to why a penalty of removal from office or prohibition should not be imposed, and the bishop's decision is subject to review by the Archbishop of the province. Now, when the cathedral's measure was in draft, the original proposal was that this provision should apply to all ecclesiastical office holders, for example, incumbents who are on the PCC ex officio. It was only when the then Dean of Arches made representations that this would be an inappropriate provision, but at the back end of the measure concerning cathedrals, that it was dropped pending inclusion in a more appropriate measure. Admittedly, cases involving the disqualification of clergy as charity trustees will be few and far between. Canon Andrew White, the so-called Vicar of Baghdad, was disqualified by the Commission from acting as a trustee and or holding any office of employment with senior management functions in all charities for a period of 12 years from 2020 due to a range of faults, including a failure to observe conflicts of interest and the proper stewardship of charitable funds of a charity established for the support of the education, health, spiritual and welfare of Iraqi Christians who have had to leave their home country and relocate to Jordan, for which he acted as an ambassador, not Her Majesty's ambassador to charity, I should say. While in most cases the decision of the Charity Commission will be a highly relevant consideration for whether the cleric should continue to hold their ecclesiastical office, the cathedral's measure, by making the removal near automatic, increases the importance of charity law to the internal governance of the church and constitutes a significant inroad into the independence of the ecclesiastical jurisdiction. I don't think I have time to mention Kids Club case may come up in questions. But there's a danger of relying on a body of law other than that written by and emanating from the ecclesiastical powers. Principally, this is because the jurisdiction is different. It is the High Court and the Charity Commission's frontline regulator which interprets and enforces charity law, not church courts. Additionally, charity law is liable to be changed by political factors which affect all charities. The independent school sector has been mentioned as a sector buffeted by such factors. Further, it makes the secular courts more liable to intervene in intra-church disputes if instead of the church being governed by its own law, it is governed by a law that applies to other institutions generally. The present call for simplification in church law, as laudable as it is, should not therefore be answered by the stripping out of ecclesiastical law, like trying to take away, clear out the gutters of the church from all the accumulated slime and bits of twigs. Take, for example, the use of bishops' mission orders, hailed as a way of setting up new mission communities and initiatives outside of traditional parochial structures. Legal practitioners, those amongst you with experience of new mission initiatives endorsed under BMOs, will attest that such initiatives do not obviate the need for law. Instead, especially with the more substantial mission communities which hold money or property, there becomes a need to set up a charitable structure, such as a charitable company or CIO with limited liability, or else allow unincorporated associations to shoulder the liabilities. Questions around payment into parish share, representation on diocesan synod, employment and property rights come to the fore. Charity law flows in from the outside, and the practitioner may look wistfully at the traditional parochial church council model, which required no solicitor to draft a constitution because it and the rules pertaining to it exist in ecclesiastical legislation. Any knowledge of the internal life of unestablished or disestablished churches or any religious bodies out there will be aware that the absence of church law, which has a force at state level, does not necessarily make the organizational and administrative life of such bodies simpler. Now, the borders between ecclesiastical and charity law are not like a thin line of watchtowers and coiled wire, with jumpy ecclesiastical lawyers putting their heads above the parapet to pick off charity lawyers encroaching from the other side. In practice, ecclesiastical and charity law has become treated as something of a family of laws, as in the old days, matrimonial law and ecclesiastical law would have been. Indeed, the professions have sort of become fused, so that practitioners practice both laws. And the constitutions of charitable bodies have been infused with spiritual purposes and put into the hands of trustees who are actual communicant members of the Church of England. But boundaries do exist jurisdictionally, and the internal laws which apply, depending on which body is governed by either charity law or ecclesiastical law, differ. Thank you.
Ian, thank you very much indeed for that fascinating lecture. I'm going to open the discussion now to questions. Just to remind you, to raise the Zoom hand if you'd like to ask a question. We do have a question here from Olga Pious, whose microphone and camera aren't working. So the question is in the chat, but I'll read it out. The Charitable Trusts Act 1853 contained various exemptions for bodies which it implied were charitable, but were not to be subject to the new system of regulation. Parish churches were not listed, which is unsurprising since they were not under charity law, but cathedral and collegiate churches were. Was there any conceptual reason why cathedrals should be treated differently from other churches?
Well, I think that's an excellent question, Olga, and I would expect such an excellent question from you. Indeed, back in the Statute of Charitable Uses, there was a caveat saying that the Eton and the colleges of Oxford and Cambridge and cathedrals were not subject to the regulation and the jurisdiction of the charity commissioners. And one could read from that, well, they would have been subject to charity law and the commissioners, unless you had that caveat in. I'm not sure about that. I think sometimes one puts these saving clauses in to be double sure that the legislation won't apply, and because those bodies with these great privileges in the land would want to be sure that they could not come within the jurisdiction of these petty charity commissioners, and that has sort of been repeated through in the various Charities Act, those carve-outs. Now, I think probably it's the case that certain parts of the cathedral could have been considered charities, certainly certain trusts that the cathedrals were holding, but that the core of the cathedral, the sort of consecrated property and the core ecclesiastical role of the cathedral would not have been subject to charity law and, of course, preceded charity law. So I think probably what this did, this exemption, was to sort of make sure that the fuzzy stuff around the edges didn't get sucked up by these charity commissioners. So that's my take on it. And parish churches have less of the fuzzy stuff, or at least did have less of the fuzzy stuff around their ends.
Ian, thanks very much, Olga. Thank you for that question. Okay, so shall we have some hands up now for some other questions? So we've got a question here from Dan Grayson.
Hi, I'm an ordinand and not particularly familiar with how this works overall, but I wondered if is there situations where church land, ancient church land belonging to churches, could have been placed in a trust, and that trust is now no longer controlled by the PCC or the incumbent, and if in that instance, would the diocese have any powers over that land or the income that would be generated from that land?
That's a very good question, and thank you for raising it from your perspective as well. And I think the issue that you raise is actually quite an important one, the idea of forgotten charitable trusts, where something might have been set up hundreds of years ago under some devised conveyance, instrument, will, and actually over time it's got lost. And I think every church, every cathedral, every diocese will have trusts and bits of property where it's actually forgotten. What on earth was this given for? And these rough edges are smoothed out over time. I mean, one perhaps could go back to some sort of record office or try and look in the records of a course of chancery to find out how this property was set up in the first place. But often it's been forgotten and is just subsumed into the general ecclesiastical or charitable purposes of that organisation. I think that happens an awful lot because every generation or two, someone packs off all the files to the record office and they never see the light of day ever again, apart from historians who may be poring over them.
Thank you, and thanks for that question, Dan. We have a question here from James Behrens. James, would you like to read it out?
I'm happy to read it out.
Okay.
Child protection law and safeguarding law is handled differently by the church and by charities, although there's a lot of overlap. Is it really, is child protection law really sui generis, to use the legal expression, a thing on its own? I mean, surely I think that the whole, whether you're dealing with a church or some incorporated organization, this happens to be a charity, there should be a common approach.
I think to answer your fundamental question, there is general law of safeguarding and protection of children. There is primary legislation which applies to all institutions. And then what those institutions tend to do, whether it's in the education sector or the church sector, they tailor it for their own setup. And that's what we've got in the church. We've got rather a lot of it. It's quite difficult to wade through, sometimes makes it quite difficult to comply with. And I think the church does this rather a lot. It will take employment law, it will take data protection, it will take planning law, and it sort of puts it into its mode, it interprets it and modifies it and reapplies it. And it's done that with charity law. For example, when church councils employ their own members, one of their members, for example, to be a verger or an organist or something like that, as a charity, you are obliged to follow the instructions in the Charities Act around the employment of trustees. But the church has modified that act and tweaked it in church legislation, and so this does happen. And I think it's jolly difficult for us ecclesiastical lawyers to keep on top of both the general law and the law as it's particular to our own institution.
Yeah, thank you.
Thank you, James.
More questions?
I wondered whether I'd excited any interest or enthusiasm when I started showing pictures of the restructuring of the national institutions of the Church of England, whether that's generated any frissons.
So maybe so we've got a couple of we've got if we go to Kate Mayo, who's got her hand up, and then we'll come to Jane, who's put a question in the chat. So Kate.
Yes, hello. My question is that Well, currently I understand that PCCs are unable to become charities limited by guarantee. And I wonder, could you explain why that is and give thoughts as to whether that's likely to remain the case and why? Please, thank you.
Well, I think the reason for that is that PCCs have their own corporate charitable structure, which is given to them by the church legislation. And actually, it's perfectly serviceable, works well, and rules around meetings and how the PCC relates to deanery, synod, and diocese synod is all set out in what we call the church representation rules, which I think is all part of a piece, part of a package. PCCs could set up subsidiary charitable companies. For example, if the PCC wanted to run some sort of business enterprise, some sort of commercial enterprise, a shop, and didn't want all the risk to be in the PCC, wanted a dedicated vehicle, it could set up its own corporate body, which would be perhaps a charitable company limited by a guarantee or a CIO. But in terms of the core functions of the church, there's really no need because they have their own status. What you may find is if you're having trouble reclaiming your gift aid, or explaining to the outside world, what is this charity? You're not necessarily registered at the Charity Commission, you're not registered at Companies House. What you can do, if you go on a church near you and find your parish, you can download a certificate of your existence as a PCC, which is quite helpful for applying for bank accounts and things like that.
Lovely, thank you very much.
Thank you, Kate. So, Jane, you've put a comment in the chat. Do you want to expand on that, or Ian can just come back?
Hi, yeah. It was just for those dioceses that are struggling to find funds, you can actually often find quite a bit of money squirreled away in these lost trusts, as Ian was talking about. And there are a large number of charities that have a purpose of supporting the church or the minister in a parish amongst a range of other purposes, but they do hold funds for that, and they're often not controlled by the church at all. They'll have entirely secular trustee body, so the diocese won't necessarily know about them, and it can often be quite a useful thing to get an enthusiastic parishioner to do some searching for you, because it can be quite a treasure trove.
That was, I recognise that voice. That's Jane Grenfell, one of my colleagues and formerly of the Charity Commission speaking, and I think that's just helpful information, really. And the National Archives is a treasure trove of all different things. It holds, amongst other things, the records of the Court of Chancery, which, as I might have mentioned, formerly was the court which had regulation of charities, and when disposing of land, certainly land over a certain value, before the mid part of the 19th century, all those conveyances had to be registered with the Court of Chancery, and those conveyances have been copied out in very large rolls, which are kept at Kew in the National Archives. So if you find what you're looking for, sometimes it can be found.
Ian, would you like to say a little bit? Just you mentioned in your lecture about Kids Club, which obviously got a lot of publicity. Do you want to say a little bit about that and what you were going to say during the lecture?
Well, it's topical because the Charity Commission have just published an opinion on the conduct of the trustees of the Kids Club company. You may remember that this is the company which collapsed and was considered to have acted in an imprudent way, and initially, the trustees were disqualified both as charity trustees and company directors, and had a real black mark against their name. And then there was a case which they considered vindicated them, and they got their status as company directors restored. And the court decided actually they'd acted in sufficient good faith. Charity Commission now said, well, we still think that they're a load of rotters, basically. The reason why I was going to mention it is because it's an example where there's a difference of opinion about the conduct of a charitable trust and acting in good faith as a charity trustee. And such difference of opinion could apply also to those of you clergy who are by nature of your office charity trustees. And you might be in a situation where actually you who have been found to be acting imprudently and you were struck off, and that has a big effect on your ecclesiastical roles. And I think even Canon Andrew White, who I mentioned, some of his supporters would say that he was really striving to help very vulnerable people in very difficult war-torn countries which had collapsed, and the way in which he used cash mules and recycled money around various accounts was all for the greater good, but clearly doesn't comply with the necessary rigor of Charity Commission and its various guidance notes.
Thank you. Okay, so we've got two questions. If we go to Wendy Matthews first, and then Matthew Chinnery. So Wendy.
Thank you. Good evening. Oh, sorry, that's my printer. I'll shut up in a minute. I just had a question in. Obviously, the deadline for small PCCs registering has been put back by quite a long way, and I think that's been welcome amongst those PCCs. But given the pressure on volunteers and on governance and things like that, do you actually think that the registration of all PCCs is desirable in the long term, or could you see other options? Because I was very struck, as many of you on this call will know, we've been reviewing the mission and pastoral measure, and one of the comments I got back from a diocese as part of our consultation was that they expect to have over 100 parishes that aren't quorate for their PCCs, and so that sense of actually just proliferating more legal charitable bodies is actually a real issue for a church, for the church, given where we are now. And I just wondered if you had a view on that.
Yes, thank you, Wendy. I think the deadline is now 2031. It was put back by 10 years and keeps on being put back. I mean, it's a large part, I think, due to the reluctance of a charity commission to have to take on so many new charities onto its register. And I'm not sure how many tens of thousands or little tilly PCCs there are out there who are not on the register. I think it is a real issue. But I would say that actually that we shouldn't let small charities off the hook. They shouldn't necessarily be in a different position from other small charities. And I mean, I'm glad that they've been given this respite, but ultimately, if they can't, do the minimum that is required to go on the register, then maybe they shouldn't be functioning. And actually what needs to happen is either that they delegate their responsibilities to a joint council for the benefice, or other group of parishes to administer their functions for them, or that parish should be dissolved and put into a bigger benefice. And I'm all in favour of saving the parish. I would also want to save the PCCs, but they need to want to save themselves. So if no one's standing for election, no one's wanting to be the treasurer or secretary, they've handed in their own notice, as far as I'm concerned, and that can only go on for so long. And it's my concern with festival churches, actually. It's all great having festival churches open for some high days, holy days, but who's going to actually look after these churches, make sure there's safeguarding, insurance, the roof doesn't cave in? They need to be under the supervision of a properly well-run, governed charity body. So I think there just needs to be a bit of amalgamation of these PCCs.
Thank you. Let's go now to Matthew Chinnery and then to William Hopkin. So Matthew Chinnery.
Thank you. Are the duties that trustees are under in charity law a function of ecclesiastical office? And therefore, if an incumbent is either suspended from the duties of office by their bishop or prohibited for a limited period by the disciplinary tribunal but not removed from office, are they still subject to their duties as a charity trustee?
Well, thank you, Matthew. You always ask the most difficult questions. I'm sure you'd be the best qualified to answer your own questions, but I'm flattered that you asked me this one. If I get your question right, correct me if I'm wrong. My understanding your question, but if ecclesiastical office holder is also ex officio a charity trustee, and if they're removed from the ecclesiastical office, what happens to the ex officio charity trusteeship? Is that your question?
I'm not talking about removed from office. I think that's clear because they're no longer holding the office.
Yeah.
The question is whether, for example, a tribunal could impose a period of prohibition for 3 or 6 months, but not removal from office. So therefore that person in ecclesiastical law is still the incumbent, albeit legally prohibited from performing their duties. I'm intrigued as to whether charity law then assumes that you are relieved as your duties as a charity trustee for that period.
Well, I think it's an excellent question, and it's a sort of another example of why it's important to map these things out, as I've tried to do. And my view is, of course, under the CDM in England, you can suspend someone from all ecclesiastical duties of their office. I would say that charity trusteeship is not an ecclesiastical duty. And as long as the trustee provides for the incumbent of A to be the trustee, that they are not also suspended as a charity trustee, so they could go on doing that. Again, I reiterate, I'm talking in a purely personal capacity, and should this situation arise in a diocese I have connection with, I might take a contrary view, but that's my academic perspective.
Thank you. Let's go to William Hopkin and then to Ed Moore.
Thank you, Stern. Ian, I was wondering whether you had any views on what charity law could or should learn from ecclesiastical law. It's quite a high level one. Whether you just had any thoughts on that.
Well, thank you, William. William and I bonded in the library of the Reform Club over Gareth Jones's history of charities, which we'd both read, and it was a very pleasant conversation. William is an eminent charity law barrister. Well, I think that's a challenging one, because I'm often sort of very critical of my own field. That is, when I say that, I mean of the ecclesiastical law. But I think actually I revised some publications on ecclesiastical law and on burial law, and sometimes when I'm speaking to friends, they say, "Oh, ecclesiastical law, that must all be very dry as dust and it never changes." Actually, when I revised the one on ecclesiastical law, so many things have changed. But on burial law, very little has changed since the last edition. And I think probably, although we've got a charities bill coming through, and there are lots of cases, I think charity law is actually more static than ecclesiastical law. It probably needs to be more static because it needs to provide more certainty to charities, so it's not going to change about all the time. But I think being agile in any legal jurisdiction is important. So I think the Commission and the Law Commission always needs to keep its wits about it to make sure that it modifies itself according to the circumstances of the day. So I suppose that is one thing I could say, that the charity law could benefit from the ecclesiastical law, is that sort of agility. The other thing would be, I suppose, what sort of charity law learned from the ecclesiastical law is it was a principles-based type of law administered in the Court of Chancery, and the canon law was very much a principles-based type of law. And I think we just got to be careful that we don't get a bit too rigid with what precedents we've got, and this case said this, so it has to be the case forevermore. I think charity law must not forget the fundamental principles under which it administers. I'm not actually sure if I believe the answers as I've just given you, but those were what occurred to me.
Thank you, and that's very interesting. Thank you.
Thank you, William.
If we have two final questions, if we go to Ed Moore and then to Alex McGregor. So Ed Moore.
Hello, thank you. My question is about the issue of the charitable purpose, the advancement of religion, and the requirements in charity law of public benefit. Obviously, the presumption for religious bodies only was removed in 2006, and it doesn't seem to have been a great deal of detailed analysis on how the public benefit requirement can actually be met, especially when you look at it from the true legalistic position. Public has been questioned, at least on a couple of court cases, but the benefit I'm not so sure about, and I'd be interested in your views.
Yeah, I was expecting more of a sea change when, I mean, some people say there was never a presumption of public benefit, but certainly that's a sort of common view, is that the presumption of public benefit for charities was abandoned, as you say, and charities needed to demonstrate the public benefit. And certainly that's the experience of charities who are applying to be registered at the Charity Commission. It's the experience of charities who, for example, religious charities such as the Plymouth Brethren, who have been accused of acting in isolation and not benefiting the public at large. I think potentially there'll be a real big challenge to religious charities due to public benefit, but it will depend upon policy considerations of the Charity Commission as to whether or not they want to push it. Because public benefit is not just about showing that some good comes from your work. You've also got to balance benefit with harm, because legislation makes clear that if there's any public harm, then the Charity Commission and the courts can have regard to that. So I think if the judiciary or the people in policy start to see religion as doing more harm than good, then actually there could be a move to be a bit strict against some religious charities. So far, that hasn't happened, but watch this space.
Thank you. Okay, actually, I see. With apologies, I see Morag's also asked a question, which has been part answered by Matthew. But Morag, can we come to you and then Alex McGregor to close?
Thank you very much, Stephen. I wasn't meaning to be called. I was just making a suggestion, really, and it's generated a few ideas. But since you've called me, I think I will hastily defer to Alex, though I note the point that it's something that ought to be looked at in the secular context. It's just clearly that could take some time to get the secular powers very interested in it. And we have got legislation coming through in the Church of England at the moment. And I don't know, but the specific difficulty about suspension may be unique to the Church of England. And that was my thinking. And to thank Ian very much for, I've heard him answering questions. I couldn't be here for the lecture itself, but the questions are very interesting.
That's very kind. Thank you. Thank you, Morag.
Thank you.
Straight on to Alex, I think.
Fine. Alex.
Thanks. Thanks for unmuting me. That worked very well. I don't think I would agree with what Olga Pierce has said with respect, because the law is one, and ecclesiastical law is just part of the law of England. The question of what the law is involves looking at all the relevant provisions of the law, and it isn't simply a matter of it being determined by charity law. One has to look at the interaction between these branches of the law. And my view would be that it's essentially a question of statutory construction, whether or not a clerk in holy orders who is prohibited or suspended can or cannot continue to exercise his or her functions as a charity trustee where their trusteeship is ex officio. So far as prohibition is concerned, I do not think that prohibition would result in the priest, deacon, bishop ceasing to be able to exercise their function, say as the charity trustee, chair of the trustees of a PCC, because prohibition under the measure is prohibition from exercising the functions of that person's orders with the capital O, and it's clearly concerned with the functions that go with being a priest or a bishop or a deacon. By contrast, the provisions relating to suspension in the CDM refer to a person being suspended from exercising any right or duty of or incidental to his office, not his orders. And I think that they are very distinct things, office and orders. Now, whether or not those who were responsible for framing the CDM back in the early 2000s really thought this through, I do not know. But I think those responsible for thinking about it now might wish to take a more consistent approach.
Thank you very much, Alex. And you've actually found the verbatim wording, which is helpful and refers, as you say, to rights incidental to his office, which I can see could extend to ex officio charity trusteeships. I suppose what I would say to that is, well, you're saying, yes, it doesn't sort of knock out the charity trusteeship, it doesn't disapply charity law, but it prevents that office holder from exercising those functions. They are prevented under the ecclesiastical law from doing that under pain of ecclesiastical censure. And I see that follows. I think it would be helpful for legislation to be specific on the point. And I think ecclesiastical legislation has generally been quite wary about trying to cover the sort of charity law spin-offs. Take, for example, that provision in, is it the mission and pastoral measure or the predecessors, around a priest in charge can exercise all the, has a sort of status of the incumbent. Priest in charge has a status of the incumbent and has all sort of rights and responsibilities of an incumbent. And in relation to ecclesiastical, I think it says in relation to ecclesiastical charities, it may be considered as a trustee. It doesn't cover non-ecclesiastical charities. So if an incumbent, sorry, if a priest in charge goes into a benefice, or rather parish, which has a village school, where the trustee says the trustees are the incumbent and church wardens of the parish, well, the priest in charge isn't the incumbent, and the ecclesiastical legislation doesn't make them the incumbent, so they can't act as the trustee of that non-ecclesiastical charity. And that comes up an awful lot because bishops are suspending benefices and appointing priests in charges, and yet all the trustees say incumbent church wardens. So I think maybe this should be looked at in the whole as to what the relationship will be for those ex officio trusteeships, which do commonly arise. And I thank you for your points, Alex, and I hope that the discussion will carry into the night in Church House.
Thank you. Ian, thank you very much, and thank you everybody for your questions and for being here. Just before you disappear, can I just remind you that the Society's future events can be found on the Ecclesiastical Law Society website. Can I particularly draw your attention to a Zoom lecture on Wednesday, the 16th of March at 5:30. That's the Reverend Robert Marshall will speak on the context of Irish disestablishment, 1868 to 1871. hosted by the Canon Law Society on Tuesday, the 22nd of March at 6:30 p.m. at the Parish Church of All Hallows by the Tower in London. The Reverend Dr. James Corn, SJ, will deliver that lecture hosted by the Canon Law Society on clergy discipline in the Catholic Church. All are very welcome to that. You can book on the ELS website. It's followed by a drinks reception. And then, of course, the ELS Day Conference on Saturday, the 2nd of April, from 10 until 4:30 p.m. at the Church of St. Alban the Martyr, Holborn in London. The subject being accidents of ecclesiastical governance, past, present, and future. Saturday, the 2nd of April. So you're very welcome to that as well. Again, bookings can be made on the ELS website. So please do book up. The Society is very active. There's lots of things coming up. So we very much hope to see you there. Thank you for joining. Thank you for the thoughtful questions. Thank you to Russell for flawlessly running the technology. But most of all, on behalf of all of us, Ian, thank you for such a fascinating lecture, and see you all next time.